Welcome back. Now we're going to move our conversation on to talking about direct examination, walking you through the checklist that we provided for you in the book located on page 217. And that checklist first starts off talking about direct examination overview. What you're doing in direct examination is you are providing the story of your case. You are asking the questions in the perfect world that the jury is thinking of as the witness sits on the stand. So as you are crafting the direct examination, it's important to take a step back and to say, all right, how does this logically flow? What is the next piece of information that I want to have? One thing that I tell my students is to think of a touchstone person, someone in their life who isn't involved in the law and who doesn't have the same kind of training that they do. What would that person want to know next? This allows you to put yourself in the shoes of the members of the jury as you craft your direct examination to properly flow the argument.
Once we've decided that we are going to make our arguments flow through the direct examination, the next step is to find a conversational tone. We want to remove the lawyer from the thought process of the jury so that it feels like it's two people talking about a subject. The idea behind this is that when we mimic conversational tones, the jury is more inclined to hear what we're saying and to read the underlying emotion that is or is not present in the language that's being used.
Just like conversational tones are important, another key part of doing a direct examination and putting it on in front of the members of the jury is to allow your tone of voice and your facial expressions to mimic what you want them to be thinking as you're going through it. So if a piece of information is shocking, even though you as the attorney have known this through months through proper case analysis, your face and your tone of voice should reflect that. Now let's move into the 7 steps for superior direct examination. And the first one should come as no surprise. It starts and ends with preparation through case analysis. If you don't know the facts of your case, you cannot possibly organize them in the most persuasive fashion. So case analysis, case analysis, case analysis. Knowing your case as intimately as possible is going to lead to direct examinations that are far superior to what you will normally find.
Now, once we've analyzed our case properly, the next step is to look at the story of this witness, his presentation, and to organize it logically. We can't have leaps in logic such that the jury member can't follow what the witness is talking about. Because we organize logically, we're allowed to be brief and succinct, but also sufficient. Now, one of the tools that we always use when organizing logically, to let the jury know where we're going, let the witness know where we're going, and to key the judge into what's happening, are what I like to call headlines or signposts. Those are those big questions that begin in one of the subparts of a direct examination that would start with something like, Mr. Witness, I want to talk with you now about the events on the evening of March 13th. Do you remember that evening? I've just placed it in context for the witness, the jury, and the court. When I do that, it's much more likely that they're going to follow our logical thought progression.
Next, we move into what type of language that we're going to use. We want to, again, follow McCarthy's rule number 7. We want to use simple language. But with that simple language, we want to make sure that we don't fall into the trap of the Charlie Brown adult noise syndrome. Wah, 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 wah. Instead, we want to vary our tone, our volume, our facial expressions as previously discussed, and our body position. That doesn't mean our body position in the courtroom. We want to remain closer to the jury box if possible so that we become that 13th juror in effect. But what we want to do is, if something's confusing, mimic that in your tone. And witness prep is key here, so that your witness knows my attorney hasn't gotten lost in the information. They're helping to guide the members of the jury with the choices that they're making. Next, you really want to make sure that you use your exhibits. Evidence and visual qualifiers in a case are absolutely everything. Juries can't just pay attention to words all the time. As much as we all love podcasts, most of us need to be doing something else while listening to them in order to actually absorb the information. Instead, visual exhibits, things that you can see, things that possibly could be touched back in the deliberation room, help the case to come alive and will often cue your witness in to get into that emotional content that helps to sway the jury to your side of the case.
When I think about the logical progression, the varying of tone and voice, the use of exhibits, I have to have the right tools in my bag as an advocate to make those work effectively. And that's where we get to headlines, point of view or orientation of the witness, transitions, and coupling questions. Now, these are really just ways in which we move conversation along normally. It's how we identify topics that we want to talk about. It's how we mirror or reflect back an answer that we get. It's how we connect logical ideas together. So a headline is, Mr. Witness, I'd like to talk with you about what you were doing when the defendant came into the restaurant. I place the witness there. They know what the subject matter is going to be. It's a nice broad question. I then go narrower and narrower and narrower until I get some really good answers that I like. So when I get a good answer that I like, I then couple that answer to the next question. So using our example from the restaurant, after the defendant raised a pistol and shot the man sitting at the table, what did you see him do? They said, he dropped his pistol on the floor and ran out of the restaurant. My next question, after the defendant dropped his pistol on the floor and ran out of the restaurant, where did you go? Now you'll notice, I'm coupling the answer. I'm putting it in the beginning of my next question. We do this when the fact is sufficiently important that we want to highlight it and underline it for the jury. We don't do it all the time, because if we do it all the time, it loses its impact. So within each piece of a direct examination, those coupling questions can be extremely powerful. Transitions. Now I want to talk about, or of course, what happened next. That's just where we move from one topic to another.
The next thing that's important to consider as you're crafting your superior direct examination is setting the scene. And how do we do that? We set that through the background information that we are able to provide through the witness, through descriptive sensory language that we choose to use, and through action words. One thing that takes your direct examination to the next level is to ask the witness, I want you to describe the events as if they were happening here in the courtroom. Where are you currently in the restaurant? By saying, I am sitting at the booth waiting for my meal to come in, there is a sense of urgency that comes into it and a sense of vivid quality to it that allows the members of the jury to allow their imaginations to fill in what we have, particularly if you're using your exhibits accordingly. We want to use that. We want to use action words. We want to mirror the language that the witness is using and the emotions that they're bringing through in order to highlight for our case. And Dean Rose is absolutely right. Looping questions and coupling questions is best done with the facts that you've identified through your case analysis as being the most important things that are going to help you prove your case the most efficiently.
Now I want to talk for just a moment about what I personally believe is the most important rule in all of direct examination. You have to listen to your witness. This is a conversation, it is not a soliloquy. The answer that my witness gives has the kernel within it for the next question that I need to ask so that the jury can understand and everyone can follow along. If my question does not flow from the previous answer, there's a problem with cognitive dissonance, with making people realize that this is either scripted or something is being hidden. So my answers and questions, it's almost like tossing a tennis ball back and forth. The questions themselves and the importance that they have, for example, whether or not they land with the jury and the jury's response, if I've done my work properly, those questions that are important that I'm maybe going to loop or that I'm going to couple to another idea, I previewed if they're a question of fact or a question of law during jury selection and opening statement. Because I want to prime that jury to be looking for that fact and to take it in and realize it's important when the question comes. And I'll use other techniques that we've discussed previously to highlight. It might be slowing down, it might be dropping my voice, it might be becoming excited, based upon how I read the jury in the room at that time, the demeanor of my witness, and the credibility of the issue that we're talking about.
Now, from those 7 superior steps, we're going to go into identifying topics. How do you pick the topic? And the first thing that we talk about with you in the book is listing the factual theories for the witness and making sure that the supporting facts are there with sources that are listed as follows: documents authored by the witness, documents associated with the witness, other exhibits associated with the witness, who they are in relation to the other witnesses, and the witness themselves. As you look at that information, what you are trying to do is to craft a direct examination that allows the witness to stick out in the minds of the members of the jury for those facts that are most important to you. Recall back to the lecture that we've given you all on opening statements where we talked about primacy and recency. Primacy and recency isn't just confined when you're doing an opening statement. You should be using it through each skill in a trial. And so when I'm working with a witness, the most important fact that I can get out of them, I want to get right to it in the direct examination. And the second most, I want to make sure that I have a good ending thing to have. The places where they're weak, the places where there are some issues, the places where there may be some attack on cross-examination, I want to put in the middle. And the reason that I want to do that is because then I get the credit with the members of the jury for being open and honest and putting it in front of them first. And I also use primacy and recency to make it less of a big deal on cross-examination. You want to make sure that you identify those documents and those exhibits that come with the witness because, again, you want to make the presentation of this witness as memorable as possible. You want the jury in the deliberation room to look at the love letter written by the scorned, jilted woman who is the other woman in a relationship, and to see her on the witness stand and recall her words, recall her testimony, and use that to help justify the decision that they're reaching about her. That's an example of why we want to make sure that we structure these appropriately and give them facts that tie the witness closely to the case to make them as important as they are to you.
Now, once we've done this type of case analysis, we've gone through the documents authored by, associated, or exhibits. Our next step is to identify which factual theories we're going to present through this witness testimonies and which one we're going to let go. Some witnesses can't testify about certain factual theories. Other witnesses, if they testify about those factual theories, it's probably not going to help your case. So you have to make this part of your analytical process as you're preparing for direct examination. The idea is that eventually you have a final list of topics that you know you've got to hit on this direct examination with this particular witness, and you identify those other topics that you're not going to address unless it comes up in cross, and then you'll handle it in redirect.
Finally, we want to talk about organizing the presentation. How do you take all this information that you've gathered and put it forward in a way that's understandable? The book offers you several different methods. Timelines or chronologies are often useful. A note of caution: a strictly chronological direct outside of with a police officer conducting an investigation can become very tedious to the members of the jury and can allow you, as the attorney who knows the facts so intimately, to accidentally gloss over things that may be more persuasive. Instead, take a step back from your direct examination as you're working on it, and again, think of your touchstone person. Think of them listening to this information for the first time. What is going to be most important? What will help them to make sense of the testimony that this individual has to offer? And then organize it in a fashion that allows your good facts to shine through and shores up your weaknesses as best as possible prior to any cross-examination by opposing counsel.
Now, when I'm thinking about a chronological presentation and I'm worried about getting bored, one of the things that I might consider is employing some of the techniques that I use in depositions practice. If I get an answer that's not quite on topic but that's interesting and the jury is following along, I might go down that rabbit hole for a little while, as long as I know the answer that we're going to get to, and then come back. That's a way of inserting almost a mini, shall we say, commercial break or an intermission when I'm dealing with really complex and emotional issues on direct examination. The thing that I want to hazard against is creating a chronology that doesn't emotionally move the jury. And we'll talk about that. Now, when we're looking at good direct examination techniques in specificity, I want you to think of a funnel that goes from broad to narrow when we're looking at open-ended questions. We start with wide open questions that set the scene, that tell us what we're going to be talking about, and then we have a directive question which narrows the subject but remains open-ended. And we'll eventually get to probing or testing questions where you challenge or appear to challenge the the testimony of the witness, and then we end with those coupling or looping questions that highlight the information that we think is most important. When we go broad to narrow in this fashion, it's almost like da-dum, 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 da-dum. The jury knows that something important is coming. And so that when we hit it at the end, we underline it, we circle it, and then we back out with another wide open question and use it to reset our conversation about another topic.
When we talk about planning and presenting the direct examination, one thing to take in consideration that we've talked about previously is the chronological examination. Sections of your direct that deal with specific events that are the most key pieces of information for a cause of action or a criminal charge can be taken chronologically so that the jury can help to understand what the witness is seeing, thinking, feeling, and thinking. I repeated thinking there, in those moments, in order to make it clear to them, to almost allow themselves to hover above the scene of events that a case is concerned with and make sure that things work out the way that they should. But we also want to make sure that we're developing cause and effect, and that may cause us to break out of that chronological examination. For example, if there is a causal moment that happens in the course of a chronology, you can go down that path of developing what that effect is, and then loop back in to what the witness would ultimately do without knowing that effect coming back in later. You also want to look at doing topical examinations by subject matter. I want to talk with you about your relationship with this person. Okay, now that we've talked about your relationships with this person, I want to talk to you about your relationship with this place. Now I want to talk with you about your experience with this kind of action that we're talking about here. By using topics and using headlines and signposts, we can elucidate what's happening for the members of the jury and also give them something that's quick and easy to remember when they're back in the deliberation rooms deciding for your case.
Now, when I think about the organization of the direct examination, I've already mentioned headlines and discussed those with you, but I haven't talked about accrediting the witness. What does that mean when we say accredit the witness? It means let the jury understand why this witness matters and what they have to say that's important to this particular case. Sometimes a person's position in society, the job that they do, their involvement is obvious. It sort of leaps out. There's a great technique that Terry McCarthy suggests for accrediting a witness that allows us to underline the importance of and the difficulty found in testifying at trial. It goes something like this. Turn and introduce yourself to the jury. Mr. Witness, why are you here today to testify in this case? A couple of things that are important there. The why are you here sets the scene for the relevancy of this witness's testimony. If you get an objection, Your Honor, I'm really laying foundation to establish the witness's relevancy for these particular proceedings. To testify here today, that's a strong word. To provide testimony, to swear under oath, to make this promise that this is true. When we testify, we're doing something that we don't do all the time, and it has a particular import. And so we want to highlight that when we're accrediting the witness. And please don't ask two questions at once, because if you ask two questions at once, neither answer will be specific and you're not going to get what you want. Loop, but do it sparingly. For God's sakes, don't read your questions to the witness. You should be able to perform a direct examination once you've achieved competency with a list of bullet points for topics. And then the question comes based upon the demeanor of the witness and the answer that they've given to the last question. So you can write out the headline, and you might write out the looping or coupling question at the end, but let the rest of it ride and connect to what the witness is saying and what you watch and see that the jury wants to hear next. If the jury is digging your chili, so to speak, well then spend a little bit more time. If they're getting bored, move the heck on. Go from the general to the specific. Brevity is your friend. No one likes to have their time wasted, and everyone assumes that lawyers are wasting their time. And remember that. Exhibits are always going to be your friend in the courtroom. You need to know how to admit them, you need to know how to use them, and you definitely need to understand which ones go back to the jury and which ones don't, because that's a mistake that you only make once as a lawyer. And then finally, build your direct examination around those key facts that your case analysis tells you you have to prove in order to meet your burden in that particular case. Don't waste time on things that don't matter. Spend that precious time where it does.
Let's talk about physicality during a direct examination. As noted in the book, you should be standing close to the jury box, off to the side a little bit in a diagonal, so that your voice carries up to the witness box and your witness is naturally inclined to give their answer to the members of the jury, the triers of fact, the most important people in the room. You want to make eye contact not with the witness, but occasionally when you really want to highlight something that the witness has just said, and you're going to ask one of those looping questions that we've talked about, you want to make some eye contact with the members of the jury as you repeat what the witness has just said. That is a small, subtle way to take your advocacy to the next level. Make your gestures appropriately. What do I mean by that? Your torso is a box of awkward when you're talking about using gestures in a courtroom. There is something natural about wanting to shield yourself and make sure that you're closing yourself off from being judged, from being hurt. Instead, make sure that your arms are out at your sides and that you're gesturing appropriately for your body type and physicality. Relax. You know what you're doing. You've taken the time to do the case analysis. You've taken the time to review best practices of how you're going to advocate. The important thing for you to do now is take a deep breath, center yourself, and begin the questioning so that it's conversational. Keep your posture appropriate for the courtroom. What do I mean by that? I mean, you don't want to be slouching over or leaning on the podium or too casual, but you also don't want to look like a Marine at parade rest. You want to make sure that you look confident, comfortable, collected, and professional as you're presenting to the members of the jury. Listen to what your witness says. Testifying, being in a courtroom is a lot of pressure. And unlike those of us who are advocates at heart and love being in this space more than anything, for many people it's incredibly intimidating, it's incredibly overwhelming, and they don't want to have to do this experience. So they may trip up. They may say something they don't mean to say. They may accidentally contradict themselves. And if you're listening attentively, you can say, wait, Mr. Witness, you just said that this was why you did that. Is that your testimony here? By having their back like that, you increase your likability, believability, and credibility with everyone in the courtroom, and you also give the witness the chance to save themselves the prior inconsistent statement impeachment that might be coming on cross-examination otherwise. Like we've talked about, react to the witness. If they say something emotional, it's okay to have that reflect on your face. If you're dealing with a hyper-complicated subject and the answer that they give is way up here, it's okay to allow some confusion to reflect on your face. You're going to want to talk with them about that in witness prep, but it's still all right because what you're saying to the members of the jury is, I as the attorney need a minute with this. It's okay if you do as well. Don't talk over the witness. Dean Rose mentioned that it's like having a tennis ball that goes back and forth in the courtroom. As you're initially practicing and learning how to do these skills, that's a great way to start to learn how that spacing works. Get your friend who's playing your witness up on the stand, ask them the question, toss them a tennis ball. When they have it in their hands is when they can begin speaking. Then, once they're done, throw it back. It's like the talking stick that we had to have in elementary school, but it works because it teaches you the pace that you want to have in order for things to be clear in the courtroom. Finally, body position matters. There's a difference between standing there with your arms crossed like this over your chest protectively, and being open and vulnerable, hiding nothing, and being prepared to go forward. Also, we want to make sure that even if we're standing over to the side of the members of the jury, that we don't ever turn our backs on those crucial people. It's a signal of respect, it's a signal of the conversation that you're having, and you want to make sure that you remain open throughout because that makes you look like the attorney with nothing to hide.
Let's talk about language for a moment. I want you to make certain that you put the right emphasis on the correct syllable. Think about the ways in which we can say a statement to make it mean very many different things. The simple phrase, I love you. It can be, I love you. I love you? I love you. I love you. Emphasis matters. Understanding where to put the emphasis within the sentence. Having that feel. Connecting the emotional message that comes from the way in which something is said is one of the tools that we have in language that we need to use. And we want to paint pictures with words. How do we do that? Touch, taste, sight, smell. Go to the senses. Whenever you've got a witness that is lost on direct examination, ask them what they could see. Ask them if they could smell anything. What could they hear? Those types of pictures always stick. It creates concrete memory and it creates concrete connection to the testimony. For God's sakes, don't sound like a cop. Don't sound like a lawyer. We don't proceed from vehicles. We get out of the car. We don't perambulate down the conveyance. We walk down the sidewalk. You have to be aware of it because we don't realize that every culture has those words that are unique. I spent a lot of time in the military and we talked in acronyms all the time. I mean, everything was either FUBAR or snafu. And that's not useful when talking with a jury. Get rid of the filler words. If you're an okay, or and person at the beginning or end of a question, you're just checking a box and moving the conversation along. Silence is your friend. Sit silently. Let the silence underline and emphasize what's important. In the same way that we search for a conversational tone, we use our voice inflection to persuade. We go high when it's important. We go low when it matters. We slow down or we speed up. And then finally, I want to end this particular block of instruction with the idea that less is usually more. And since less is usually more, we're going to take a break now, and we'll see you in the next video.